Hi, I'm Carl Pearson, an attorney for homeowners and small businesses, and I have this video number 36, Defend Franchise Terminations as if a foreclosure. And in this video, I'm going to explain how you, the owners of a franchised or licensed business, should deal with threats to your business franchise or license the way a homeowner should deal with a threatened foreclosure. The similarities are remarkable. Here is how you should use foreclosure defense techniques to stop a termination of your franchise or license. Also, for your information, I am able to represent homeowners or small businesses in a lawsuit commenced in any state in the United States through use of local counsel. Now, here's the problem. The downturn of the economy nearing depression proportions for many is creating a large number of franchisees and licensees who increasingly are unable to comply with the terms of their agreements, which were created in better economic times. This video explains what can be done and is intended for hotel or motel owners or others threatened with a termination of franchise for non-payment of royalties or other breach of agreement, franchisees or licensees burdened with excessive franchise or licensing fees or royalties, and franchisees or licensees threatened with foreclosure because of alleged failure to comply with various terms of the agreement. There are many similarities between franchise termination and mortgage foreclosure. For example, a bank or franchisor supplies the capital or service, that is, reservations in hotel and motel situations, without which the homeowner or franchisee loses the home or business. 2, a bank or franchisor charges more than the homeowner or franchisee can pay. It's called usury in case of the bank, and excessive fees and royalties in excess of what the business can pay as to the franchisor, or predatory franchising. The homeowner and franchisee is stuck with a bank or franchisor, especially when unable to make the required payments. The homeowner and franchisee are left trying to renegotiate their agreement, called a modification agreement or forbearance agreement, as to the bank, and it could be called the same thing with respect to a franchisor. 5, the homeowner and franchisee exhaust all of their money trying to meet the payment requirements and only seek help after they run out of money. That's ridiculous. You should not fall into that trap. 6, intervention by the court is the only way to solve your difficulty if you can't reach agreement, short of bankruptcy, which I don't usually recommend. 7, going into court yourself as homeowner or franchisee may cause the bank or franchisor to give you the modification agreement, which they otherwise wouldn't give. And 8, franchisors, as banks are able to do in non-judicial foreclosure states, can terminate your interest in the franchise without going into court. So the remedies for a homeowner in non-judicial foreclosure states suggest what a franchisee needs to do to defend his franchise. Here's a game plan for franchisors without considering what rights may exist under federal and state dealer day in court and franchise termination statutes. You have to explore that as well. 1, hire an experienced litigating attorney as soon as you see a problem arising. A strictly transactional attorney may not be able to do what you need, which may be to commence a lawsuit as quickly as possible. 2, determine from the franchise agreement and any guarantee whether arbitration is required and any special venue requirements. 3, put together all of your evidence showing the ways in which the franchisor has been abusive to you, predatory franchising, including fees and royalties not supported by the income generated from the use of the franchise or license. Include your franchise files, emails, notes, correspondence, income records, records showing payment of fees and royalty, demand letters, notices, etc. 4, gather information from the franchisor's website and SEC filings and any, quote, franchisor sucks websites, complaints on internet, industry publications, and reported lawsuits in the state and federal courts to show problems that the franchisor may be having with its franchisees generally, to give you an idea of what services they're failing to provide. 5, before revealing what you intend to do to protect yourself, determine what you might be able to obtain from the franchisor, such as statistics showing how other franchisees are faring, or any documents showing how they are supporting or not supporting your business. Talk this over with your attorney to see what kind of documents you might be able to get before starting anything adverse against the franchisor. 6. Your attorney prepares a summons and complaint with various causes of action in support of your predatory franchising claims, including failure to comply with 16 CFR 436, the FTC disclosure requirements and prohibitions concerning franchising and business opportunity ventures, fraud and misrepresentation, special pleadings as to any arbitration provision, very important, breach of the implied covenant of good faith and fair dealing, breach of contract, rescission, accounting for the monies you gave to the franchisor, some of these in the alternative. Also, you should determine if there's any force majeure or act of God provision which might enable you to demand a modification of the agreement based on proof of a substantial recession or depression. 7. Perhaps you'll need an order to show cause to obtain a temporary restraining order and preliminary injunction prohibiting the franchisor from terminating the franchise during the pendency of the litigation. Warning, there may be some bond requirements there. 8. The filing of the lawsuit and service of the summons and complaint and any order to show cause may cause the franchisor to rethink its position on giving you a workable modification agreement to be able to settle the lawsuit. Be careful in any settlement that you do not put yourself in a worse hole. Ask your lawyer what this means and make sure you can comply with the terms of any settlement agreement. This, in a nutshell, is what every franchisee should know before having any problems develop with the franchisor. I'm always available to talk with you about your problem, and I am able with local counsel to represent franchisees or licensees in any state in federal or state court. My website is carlperson.com. and my telephone number is 212-307-4444, and I'm presenting this to you on the screen right now so you can see it. And I thank you. I look forward to having you give me a call if you have any problems. I am always able to help, I hope, and I look forward to hearing from you. Thanks.